Number 93.
Ready for 4, please.
Counselor, you want any rebuttal time?
Yes, 4 minutes, please.
Okay, go ahead.
My name is Alan Sklar, representing Stallion. First, I just want to say what an honor it is to be arguing before the New York Court of Appeals for the first time. About 20 years ago, when I was starting my first argument, that was a moot court argument down in law school, I was nervous, just like I may be a little bit nervous here.
It's okay. You're allowed. Go ahead.
There was a gentleman who was playing one of the judges at the time, and he said, "Look, son, you look nervous. Just get up there and tell them why being on your side, being on your client's side, would be fair. That would be the fair thing to do." And that's what I'd like to do here. And what I'd also like to do, and it kind of touches upon what Judge Jones had mentioned in the prior matter, where he said, sometimes, and I think he spoke about founded suspicion, which is sometimes it's easier to define something by what it's not, to look at the inverse or the invert, which Carl Gustav Jacob Jacobi, actually a mathematician, had made famous in the 1800s when he said invert, always invert.
Well, let me ask you a specific question. Why doesn't subdivision B that talks about acceptance, delivery to an addressee who accepts it voluntarily, why didn't that cover the service in this case, since the executive secretary apparently took the service of process and didn't indicate that she wasn't authorized to do that?
That's a great question. I would say that it has absolutely nothing to do with the case, nothing to do with the Hague Convention itself. The Hague Convention is very clear in that it says if you're going to, if you're going to go ahead and where a foreign party elects to go through formal channels, which is what the foreign party did here from France, it must be translated.
How is that clear? I mean, is it really that clear?
Yeah, it's very clear because
off from websites, or what's the authority that you cite for that?
It's the pronouncement itself. If you look at page 108 of the record, where it says that the U.S. In all instances where a foreign party elects formal channels, it must be translated. And here they use the Process Forwarding International group to go ahead and serve process.
Well,
and under that, it's very clear.
This whole issue probably could have been resolved if the contract had in it, if the contract between the two parties here had indicated that any service was to be translated into English, correct? I mean,
well, I tell you,
the contracting party here knew that they were using France as the venue, and they knew they were submitting to the law of France. So it's not as if it was inconceivable that documents were going to be in French.
Well,
and yet the contract doesn't require that it be bilingually presented.
Well, the contract requires that we submit to the jurisdiction. It does not require that we waive our right to due process, and we waive our right to notice. And that's actually what occurred here.
Does it really come down to a due process problem here? That is, isn't the question really the adequacy of notice rather than the formal compliance with the strictures of the Hague Convention?
It certainly comes down to notice, Your Honor, as well. Here, it's very, very clear that they were not given proper notice. And if you take a look at the record, it's very clear that the Hague Convention and the U.S.'s pronouncement here. And they made a pronouncement very, very clear, just like a bunch of other countries did. And I can list the countries for you. They made pronouncements. They didn't say it was a declaration.
But this pronouncement was in the form of an answer to a questionnaire on a website. Isn't that a little funny way to make law?
Well, no. This is a pronouncement pursuant to the Hague Convention, which is the law of the land, which my adversary says is the law of the land. And if you look at the website,
but the Hague Convention says you may require translation. It doesn't say you do. And other countries issue these things called declarations, says we hereby require.
Yeah, but they make those declarations only for one particular reason and regarding certain sections of the Hague Convention. They make those declarations pursuant to Articles 2, 15, 16, and 29 to the Hague Convention, and they specifically state on page 180 of the record, where they, in Article 21, where commencement on service abroad, you must make declarations, an agreement or opposition to those particular articles. It leaves out Article 5 of the Hague.
But what
Is it
happened?
significant here? Oh,
What,
thank you. Is it significant here that a more current declaration excludes English and French?
I'm not sure I understand, Your Honor.
Isn't there a more current declaration?
2008 one.
A questionnaire, answer to a questionnaire that says that everything has to be translated except if it's in English or French. Does that have any significance here?
Except if it's in English or French. I was looking at
It's a 2000.
our pronouncements in pages 281 and 282 of the record, which is section 9.1, which is where the central authority designated by the United States had specifically explained what they mean by the translation requirements.
Well, I guess I thought I had read in the record, too, and I think this is what Judge Saperica is getting at, that I think it was in 2008, that it would be okay, that it was recognized that the French language was fine, English or French would be fine. No?
I'm sorry, I'm unfamiliar with that
All
at
right.
this point.
if you cut to the
I can point
chase,
to
I
it,
guess, here, your complaint is that you never knew you were being sued because they served the wrong person?
No,
Your complaint is that you didn't know you were being sued because the right person was sued, but she couldn't read French?
Look, you could serve this thing 150 times. If you serve it in French or Swahili or whatever language you would serve it in, they served it in the United States to someone who clearly did not speak French.
Would
and
the
Hague
case be
Convention says
different
that's wrong.
if the person who received it happened to speak French? Would that solve the problem?
No, it would not actually. And I tell you, there's actually a case, Berta, which actually the United States, Court of Appeals, where they spoke about, and it was cited by my opponent, where it says there that, look, there was no telling whether he understood or not. In that particular case, it was not a situation, of translation, and that was actually cited by the court, by the appellate court here, where the appellate court had cited Berta to say, well, this is somebody who shied away from service and actually did get service and probably understood it. But it's different because this is a translation issue here.
Right,
this is a case where the Hague Convention and the United States specifically goes on and on and on. There are explanations as to why these things have to be in the country. In other words, if it was served in Germany, it would have to be in German.
So is your argument that the right person was served, it was served in the wrong language, and therefore we decided we did not have to respond?
No, the issue here was that we don't know whether the right person or wrong person was served, and it almost doesn't matter here.
Don't you think, counsel, it behooved you to try and find out what the French papers meant?
Well, it's a very, very difficult thing. You're serving upon a clerk is being served in French, and...
But did you, what I'm asking you is, did you really just choose not to contest it, even knowing that you were being sued and we're just not going to bother the translation?
Well, Your Honor, I think we'd be crazy to do so. Why would any intelligent person do that and just ignore it?
So again, I'm not saying it's judgmentally, I'm asking
Sure.
you chose not to find out what it meant.
I have no idea whether the clerk who received these papers knew what they meant and just put them aside. And it had to go from the clerk, to maybe the owner of the company who had some basis.
You're conceding that your client probably would have been wiser to do a better investigation, but you're saying it doesn't matter whether he made a mistake or not, he didn't have adequate notice.
Even if my client had taken the documents, even if the clerk had taken the documents, gone to the trouble, which is not our burden, by the way, but had gone to the trouble to try to translate these documents, it still would be incorrect under the Hague. And there are real reasons for this, because how are we to tell, from one case to the other whether they truly understood the documents or not? You're not going to get to that.
Let me ask you a different question, which I think maybe Judge Graffio was on before. What does the Hague Convention mean when it says the document may always be served by delivery to an addressee who accepts it voluntarily?
Sure. They only mean that when they're talking about non-formal service. When you're talking about formal service, as explained in in the U.S. See, the U.S. is able to interpret, the Hague, and is able to comment on it, and they specifically state that that if it's a matter of formal, if they go through formal service, then
what do you
then
mean
you
by
have
not-
to translate no ifs, ands, or buts, whether it was
What do you mean by
voluntary or whether it was not.
non-formal service?
Sure.
You mean a consent to accept service?
No, Your Honor, formal service is, it's a service of process where you go through the Hague Convention, where you go through the central authority of the United States, which in case it would be here, and where the French folks go ahead and they serve by going to.
So you mean by non-formal, you mean a service other than through the central authority of the receiving state?
Well, actually, it's through.
So the
if you're using the process forwarding.
The U.S. Marshal is not central service? I'm just trying to understand.
Sure. There was a company called Process Forwarding International, which is exclusively used by the folks in the United States, and
Well, who retained them? The U.S. Marshals retained them, correct?
the U.S. Marshals retain them, and so does anyone else that pretty much wants to effectuate service.
if it's-
usually,
if it's-
but by informal, I wanted to answer your question. By informal is, let's say they didn't go through the Process Forwarding International, which they don't have to do. Then they could have gone ahead and could have hired. Someone who would have just gone ahead and gone right there and go ahead and serve.
And if the recipient says, and if the recipient takes it in his hands, that's okay? Then you can
If the
forget the Hague
recipient would have
Convention?
taken it in his hands and voluntarily accept service, and service is good, then there would be no
In
argument.
other words, if I send a messenger from next door to your house with a summons in French, and you take it and don't give it back, that's good service. But if I take the same summons, put it in an envelope, send it to the U.S. Marshal puts on a uniform, comes to your door, does the usual ritual, that's not good? That doesn't make
Well,
any
no,
sense.
Judge. Actually, it's a very good point. But actually what I'm saying here is that if you had gone ahead and gone through informal service, the court system would probably say that French papers would not have passed any muster here because it wouldn't give them fair
no matter
notice.
how informal the
But
service
now
is,
it's
the notice isn't
guaranteed.
good.
But now it's guaranteed. We
Okay.
had informal service, there'd be an argument to be made, and I think we'd win the argument anyway. But that's why service of process.
Okay, counsel.
Thank you,
Thanks.
Judge.
You'll have rebuttal.
Thank you, Judge.
Counsel?
If the court please, my name is Ted Porras, and I represent John Galliano. Your Honor, New York State has historically been a hospitable forum for the enforcement of foreign country money judgments, something that was pointed out recently by you, Judge Profeo, in the CIBC case in 2000.
We're also concerned with proper notice that provides due process of law. So how did they know what this lawsuit was about or for how much?
Well, the record shows a lot of different reasons that they knew what this law was about. First, Judge, there's a forum selection clause, as we've heard. They agreed to be sued in France where they litigate in French. Prior to that, we all agree, there was protracted discussion in English through American lawyers for both sides that culminated in a letter in English to Stallion that said, if you don't pay us this amount.
Do you need those facts? I mean, are you conceding that if you didn't have the kind of equities on your side here, this would not be adequate notice?
No, Your Honor. I think
Suppose this were a tort suit, no contract anywhere, nobody consented to anything, and and somebody serves a summons and complaint, not in French, in Japanese. Is that good service?
Yeah, it is. If the service is reasonably calculated to apprise the recipient of it that a lawsuit has been filed in a foreign country and for a certain amount of money, and that they have to do something, the answer is yes.
Well, but I guess some of us would have some doubt that your average Japanese document would apprise the average resident of the United States of anything.
Agree, but here we have.
French may be different, but are we really going to make a distinction between French and Japanese?
The distinction that the court below made was that we have a forum clause here, that we have the agreement to litigate in French, and that takes us within the exception of 5305A3. A limited exception, granted, but one that applies clearly
Well,
here.
you take that to mean the 5305A3 says we'll recognize anything if the court had jurisdiction.
Yes, Judge.
Yeah. So you take that to mean that if there's a submission to jurisdiction in a contract, that's like a confession of judgment. You don't have to serve anything?
No,
recognize the judgment anyway?
If you submit to the jurisdiction of a nation that has impartial justice, as you have held France does, and that provides justice compatible with our notions of due process, as you have held France does, then if you submit to the justice of France, you submit all of it.
But you still need personal jurisdiction. That doesn't mean that you don't need personal jurisdiction, right?
Agree, Judge, but that's an issue that you should be arguing to the French court.
Suppose they didn't serve anything at all, and they persuaded a French court it was okay. Could we refuse to recognize the judgment?
With respect, Judge, I think you could not. I think you have, because this is a court in a country that respects due process, you have an argument to that person to say, go back to France and argue it there. Here, even if a judgment was entered, the Hague Convention and French law requires...
So aren't you really interpreting the confession, the jurisdiction clause in the contract as almost a confession of judgment? You're saying do anything you want in the French court?
If this was the court of a nation that wasn't fair, that didn't respect due process, I would be with you, Judge Smith. But we are talking about a court whose jurisprudence we have all recognized.
France, or let's say England or something like that, they are different. You are making a distinction between those countries and other countries maybe who aren't as known for respecting due process.
Not just me, Judge Lippman, but 5304A of the CPLR and lots of prior case law. This court and the federal courts have rejected cases in recent years that came from the Iranian court system. There was a recent decision from the Liberian court system. There was one from Sierra Leone.
Don't you put the American courts in an awkward position where we might have to be deciding whether, say, the Russian court system or the Greek court system is fair enough for us?
Well, the statute presents that problem. I don't, Judge. And again, we're talking about a uniform statute that is in effect, I believe, in 32 different states of the Union. So we make that decision every day, and case law says that.
Mr. Porras, if they make the argument, and this isn't just French, I mean, it happens with Canadians too, but if they can attack the original service and say, I never got service, forget, whether or not Ms. Mao or whoever was authorized, was said, we never got service. There was sewer service here. And so now they're coming back here with a French judgment. How should that be handled? I mean, don't they have a legitimate right to oppose the filing and the enforcement of that judgment?
I think you should take that issue back to the French court, and the French court gives you a year to do that.
And if it happens, if it's the rule in France that they're going to regard the process server's affidavit as conclusive and they don't care whether you say it was sewer service, then that's too bad. The defendant is stuck with the French rule.
Well, we don't know that that's what the French courts do.
No, I'm not making it up. But if that's the case, you're stuck with it.
This court has found repeatedly in the Sungwon decision in 2006 and in CIBC Mellon before that its role in reviewing foreign judgments from courts that are fair is minimal.
So we don't look so closely at what they do. You're saying that's what we've said, that if it's France or England, we just don't look closely at it.
My question was a little...
The statute is comedy,
Mr.
Judge.
Porras, my question is a little different from that. I understand comedy. But if France... Somebody is in France in a court saying, I don't know where my opponent is, but we're about to enter a judgment for $300-some thousand, Judge, and, they're not here, so we want a judgment. I think France, if they are given the appropriate documents to satisfy them, are done. Does that necessarily follow, then, that the courts of the state of New York are foreclosed from finding out that that plaintiff, not necessarily you, but a different plaintiff, engaged in some activity that made that judgment unfair here, that it was a denial of due process here?
I think giving deference to a foreign court means that except in the most egregious circumstances, the court's role is not to look behind the curtain of the foreign court.
I disagree with you. I understand that if a French judgment comes over here, they may say, listen, if it's a legitimate French judgment, our mistake, we didn't get over there. But the fact of the matter is that we never got notice of this. This is wholly made up. And your argument is that they got to make that argument over in France.
Yes.
Their argument is due process in this state does not mean we close our eyes to anything that happens in any foreign jurisdiction and we're bound by it. Now, don't both of those arguments have a certain sense of fairness to them, and shouldn't we decide?
Yes, they do, but I think the balance tips when you look at the language of 5305A3, which, again, deprives the court of the opportunity to look at personal jurisdiction. And after all, that's what sewer service implicates. Personal jurisdiction if there is a forum clause. If that provision means anything at all, it has to mean go see the foreign court that you agreed to litigate.
So what is the most egregious circumstance that you say? What would be a circumstance that's not good enough?
Well, I think Judge Piggott gave it to us, Judge Lippman, which is sewer service. There was no service.
So in that case, you could say gee, and I don't know what went on there, it's France, but not good enough here.
And I'm glad I'm not arguing that position here today. We don't
You-
have
you-
that.
you-
that
you-
problem.
you are- your position, if I understood it, is that even sewer service is good enough to make you go to France to get the sewer service undone.
5305A3,
That's a yes?
yes,
Okay.
unequivocally says
But
that.
how, what's your fallback position? Assume we're reluctant to go that far. What is the rule? Is
My
there a
fallback
more
position
moderate rule you can propose?
Is maybe, Judge. Again, in the case of a truly egregious and a truly clear violation of the most basic standards of due process, which we do not have here, far from it, the court, I cannot tell an American court that it has no role whatsoever to play in reviewing notice to an American defendant sued in a foreign court.
Doesn't A2 give it to us?
A2 by its terms doesn't appear to. It appears to relegate to the foreign court all disputes. That's, at the end of the day, what they agreed to litigate, not just the substance, not just the damages, but everything.
The First Department said that A2 declares a foreign judgment to be not conclusive if the foreign court never had personal jurisdiction over the defendant. And that would seem to imply that that court, the First Department in this case, says we decide whether it's conclusive or not if there's no personal jurisdiction.
That's 5304A2, and I would
sorry.
ask you to
You're
read
right.
that
You're right.
together with 5305A3. You can't read either of those sections in isolation, Judge Piggott, and together 5305 says that to the extent that there's a jurisdictional argument under 5304, it's taken out of the equation by a forum clause, which is what we have here. And again, we're talking about the minority of cases and the narrow exception to the rule you might otherwise choose to apply.
Can I ask you to switch to the Hague Convention, because your adversary claims that there's certain provisions there that you didn't abide by?
Okay.
How did you affect proper service under the Hague Convention?
Well, we effected proper service, I think, under both paragraphs 5.1 and 5.2, Your Honor. And in this set of circumstances, those two aspects of service aren't very different. The original affidavits of service, not the amended ones the counsel has exercised about, but the original ones say that the process server in all cases went to the principal place of business of Stallion, and they presented to and left with the receptionist in each of these cases. Presented to and left with is not very different a formulation in the English language than voluntarily accepted by, especially in the absence of any disagreement.
You take that with the words, an addressee who accepts it voluntarily, to mean basically anyone who closed his or her hand on the document without being forced at gunpoint to do it has accepted service?
Yes. And actually, other courts have ruled the same
If
thing.
it's that easy, why do people go through all this? I mean, very few people, when you hand them an envelope, will throw it away.
Well, you know,
It's easy to, and that's very easy to serve under the Hague Convention.
there are a number of cases decided under the Hague Convention where that very issue is discussed. Greenfield and Suzuki by Judge Wexler in the Eastern District. No evidence that they refused to accept service.
Should we decide our case under the Hague Convention?
I don't think you need to decide this case under the Hague Convention, Judge Lippman. I think Rule 5305A3 means what it says, and I think that is a sufficient rule of decision for today.
Let's go back to that for a second.
Okay.
I understand that
I'm not done talking about the Hague.
To go back to 05, though, I understand that that gives personal jurisdiction. In other words, they can't go to France and say, long arm, you can't get us, we never were in France, et cetera. I don't think that necessarily means that service of process is out.
Well, I mean, what's personal jurisdiction mean?
It means that you're subject to the jurisdiction of that court, but you still have to get it. I mean, in other words, you couldn't walk into that court and say, the defendant here is submitted to the jurisdiction of this court, so here's a document, we'd like you to stamp it saying there's a judgment. I think it still means you got to get service.
Well, two different things traditionally go into the courts taking a personal jurisdiction. One is proper service, of course, and the second is all the international shoe tests, minimum contacts and sufficient notice. I mean, 5305 and 5304, which uses the same term, uses the term personal jurisdiction in both cases. It has to mean the same thing in both provisions of the CPLR, and it can't be that personal jurisdiction means only notice or only service. It has to mean what we traditionally enforce that term to mean.
I took you away from Judge Graffio's question. I apologize.
Was I done?
Well, I was going to ask you why the documents didn't have to be translated in English.
Well, they don't have to be translated in English because The United States doesn't require it, and that ought to be plain. No courts held
What
the
about the
contrary.
directive?
What we have from in the record from counsel, most of which comes from a Freedom of Information Act request, is nothing at all like the ways we make law in this country. We don't have a declaration to the treaty. If you look at page 190 of the record, you'll see that England declares. So when counsel tells you that's not the place to tell the world, after all, that's where counsel in other countries look to see what requirements are when they want to sue somebody here. That's just not correct. So there's no declaration. The United States Department of Justice is the central authority. If there's anything they know how to do, it's make regulations, but there isn't one. There isn't a statute. All we have is an answer to a questionnaire reprinted in a website, reprinted in a handbook, and some circular notes from the Department of
Is
State.
it relevant in your view that the designee, the private contractor that was the designee of the central authority didn't send the thing back when it was only in French?
It is relevant, Judge, for the same reason that Judge Wexler in the Greenfield case discussed that very issue. The service under the Hague Convention is ordinarily supposed to be made according to the way service is requested to be made. And the record shows that the French demand in all three instances of service asked that service be made according to 5.2 by voluntary acceptance, terms of plain meaning. They didn't fill out the form to say that, needless to say, but the affidavits of service establish it. So it was served clearly in accordance with the request that was made, and that's how courts traditionally evaluate service under the Hague Convention.
I was puzzled that the Department of Justice is on record, admittedly, in these kind of informal, weird ways that you have to search the web or do a Freedom of Information Act to find, but the Department of Justice is on record as saying, translate these things. Why, when they get an untranslated document, don't they say, hey, read the website, translate it?
Well, you know, what we have is what the Department of Justice says, spoken through the text of the treaty itself on page 191, and they don't say that there. What the Department of Justice might think of as a good guidance to counsel or as a better practice is one thing. What we enforce as the rule of law, it certainly is another, and it can't be a website, a questionnaire answer, or any of the things that have been offered to us.
Okay, counsel.
Thank you all.
Thanks. Counsel Rebuttal. Go ahead.
Thank you.
Do we have to decide this case on the Hague Convention?
I think the Hague Convention is a very, very important part of this. And the statute 5305, subsection 3, really has very, very little to do with the issues in this case. The issues in this case...
So you have to decide it under Hague?
You have to decide it under Hague, which is a supreme law of the land, which counsel, admits. And by the way, on page 135 of the record, he actually says in one of his briefs that it indisputably governs this action.
Does that mean, get some legal advice here, that when you get something in the mail from the Italian police saying that your daughter was speeding in her rent-a-car and she owes whatever 480 lira are to the government, that because it's all in Italian, I don't have to respond?
Well, if it's all in Italian, it's excusable if they don't respond, because they have no obligation to go ahead and translate these documents that they don't even know what it is.
So
which is why specifically that CPLR 5305, subsection 3, there's a reason why it wasn't briefed, below, before the appellate division, and there's a reason why that statute wasn't briefed even below that in the IAS court. It's because it's inapplicable, because it's a red herring. Subjecting yourself to jurisdiction pursuant to a contract is very, very different from getting fair notice. And if you take a look at that statute along with the statute that many of us are more familiar with, which is Section 302, which is a long-arm statute, which deals with obviously the long-arm statute going from one state to another rather than going from one country to another, which, by the way, this court actually said that's a good analogy. If you look at Sung Wan Company versus Rite Aid, this court actually did say that 302 is really used as a parallel to this other statute with respect to personal jurisdiction.
But you
Section
still
302, you wouldn't go ahead and say, well, if something was incorrect, with the service there, well, okay, they subjected themselves to the jurisdiction of that state.
So what you're saying there, though, is I admit that my client is subject to the French jurisdiction. I just never got notice.
That's exactly
right?
correct, and that's the whole case.
But don't you have the third person who got this writ simply said she didn't have authority to accept service, I think, but she never said, that she wasn't a person of suitable age and discretion. I'm wondering, there are three writs.
It's interesting because I tell you something, the third writ there was an affidavit of service which is identical to the first two, and then all of a sudden, mysteriously, 3.5 years later, in opposition to our motion, counsel on the other side gets one that says, voluntary service actually changes and submits an amended, but, I would even argue even that it really doesn't matter. Even if everything that they said 3.5 years later, which I think is incredible that they would be able to go ahead and do that, but even if they did say that, it wouldn't matter. The Hague is a supreme law of the land. And by the way, this is not a this is not just a website. This is the Hague's. I'm just addressing your point, actually. This is the Hague. This is not just a website. This is not pursuant to the Freedom of Information Act. This was something where I can go on in 90 seconds and I can get this information.
But suppose you lose. I mean, suppose this is in conformity with the Hague Convention. I know you say it isn't. And suppose, but suppose you haven't submitted by contract. Suppose we were to find they've complied with the Hague Convention. Is there still a due process problem?
I'm not sure I understand the question, Your Honor.
If the Hague Convention doesn't require any translation at all, suppose neither the Hague Convention nor anything the United States government has done pursuant to the Hague Convention, nothing there requires a translation.
Right.
Does due process require a translation?
I think it does. Due process and fair notice, it certainly does, which is
what
why...
What about that Julen case in California where they say you don't have to do much, but you've got to do something in English? Is that...
That's exactly one of the cases that I was looking at. In California, they said, look, at a minimum, a defendant should be informed in the language of the jurisdiction in which he is served. And they said the same thing basically in Ohio, in Ward versus Ludwig. We don't think that a trial court should have to determine on a case-by-case basis whether a defendant understands English.
Okay, counsel. Good. Thank you.
Thank you.
Thank both of you.
Thank you.
Appreciate it.